So India has just rolled out a brand new data law, the Digital Personal Data Protection Act, or DPDPA. Now, if your business is already GDPR compliant, you might be thinking, been there, done that. But I'd say don't get too comfortable just yet, because while the goal is the same, the rulebook is surprisingly different. And ignoring those differences, that could turn out to be a very, very expensive mistake.
And let's talk about the stakes, because they are massive. Non-compliance could hit you with a maximum penalty of 2.5 billion rupees, which, for perspective, is roughly 28 million euros. A number like that isn't just a slap on the wrist. It's a clear signal that this new law has some serious teeth. So this leads us to the one big question I'm sure is on a lot of your minds. Hey, my program is built on the GDPR, the global gold standard. Surely that's good enough for India, right? Well, the short answer is no, not quite. While there's a ton of overlap, India's DPDPA has its own unique philosophy, and that's exactly what we're going to break down today. All right, so here's our game plan. We're going to start with the basics, just to get our bearings. Then we'll dive into what is maybe the biggest change, the grounds for processing data. After that, we'll look at some new rights and obligations, tackle the rules on breaches and borders, and then wrap it all up with a clear, actionable takeaway for you. Sound good? Let's jump in.
First things first, let's get the terminology straight. The DPDPA uses some new labels, but don't worry, they map almost perfectly to the GDPR concepts you already know and love.
Okay, so think of it this way. Under GDPR, we talk about a data subject. In India, they're calling that person a data principal. And where GDPR has a data controller, India now has a data fiduciary. It's a pretty straightforward swap. The individual is the principal, and the company holding their data is the fiduciary. Simple enough, right? Great.
Now here's where we hit our first real surprise. The law specifically focuses on digital personal data, but look at that exclusion. It doesn't apply to data an individual has already made public themselves. So if someone, for example, posts their own phone number on their public social media profile, that information falls outside the scope of this law. That's a huge difference from the GDPR's much, much wider net.
And that brings us right to our first truly major departure from the GDPR framework, the legal justification, or what we call the lawful basis for processing personal data. This is where things start to get really interesting and a little tricky. With GDPR, we're all used to having 6 lawful bases to choose from. Organizations rely so heavily on things like contractual necessity to, say, fulfill an order, and legitimate interests for just about everything else, from marketing to network security. I mean, these are the real workhorses of most compliance programs. Okay, now take a look at India's framework. That list is dramatically shorter. You're basically left with 2 main options, getting explicit consent and a pretty narrow list of legitimate uses. And just like that, 2 of the biggest, most used pillars of GDPR compliance have completely vanished.
So let's be crystal clear on this. The DPDPA has no equivalent to legitimate interests and no broad basis for contractual necessity. This isn't just some minor tweak, folks. It's a fundamental gap that is absolutely going to require a whole new approach for any business operating in India.
So what does this actually mean for you on the ground? Well, think about direct marketing. Under GDPR, you might have been able to justify it using legitimate interests. In India, that justification is gone. Poof. Now, you will almost certainly need to get clear, unambiguous consent to do the exact same thing. That's a huge change to your whole marketing workflow.
Now, on top of changing the old rules, the DPDPA also introduces some completely new ideas, rights and obligations that, frankly, just don't exist in the GDPR playbook at all.
First up is the right to nominate. This is a fascinating concept. An individual in India can now officially name someone to manage their data rights if they pass away or become incapacitated. Think about what that means for your company. You're going to need a whole new process just to verify and handle requests from these nominees, which is something your GDPR framework would have never planned for.
Next is the right to grievance redressal. This one's a big deal for process. Before a person can go and complain to the official Data Protection Board, they must first go through your company's own internal complaint process. So this means you are now required to set up and maintain a really accessible and effective system to handle these issues directly.
And then we have consent managers. Picture these as new, registered agents who can manage a person's consent choices across a bunch of different services, all on their behalf. For your business, this means your systems can't just be built for individual users anymore. They'll need to have APIs and processes to talk to these new authorized third parties.
All right, let's switch gears to two critical operational areas that see a huge divergence: data breaches and data borders. And it's a bit of a twist because one gets a lot stricter and the other, surprisingly, gets a whole lot simpler.
With GDPR, you've got that risk threshold, right? You only have to report a breach if it's likely to pose a risk to people. While the DPDPA basically throws that whole idea out the window. The rule is black and white. If there's a personal data breach, any breach, you report it. Every single time. There's no judgment call, no gray area. But here's the twist. While breach reporting gets way tougher, data transfers get easier. A lot easier. GDPR transfers can feel like you're navigating this complex legal maze of adequacy decisions and SCCs. The DPDPA, at least for now, is more like an open highway. You can transfer data pretty much anywhere in the world, unless the Indian government explicitly puts up a big stop sign for a specific country.
So after all that, let's bring it home. What does this actually mean for your compliance program? What are the key things you need to do right now to bridge that gap between your current GDPR setup and these new Indian requirements?
Here's your 4-point action plan. Number 1, you have to review all your legal bases. For any Indian data, you can just scrap legitimate interest. 2, update your entire consent process to meet this new higher standard and get your tech ready for consent managers. 3, build that required internal grievance process from the ground up. And 4, revise your breach response plan for this new report everything reality.
And one last really crucial warning, this is not the final word. The DPDPA is what we call umbrella legislation. It's the high-level framework. There are more detailed rules that are still expected to come out that will fill in all the gaps. So this means compliance isn't a one-and-done project. It's going to be an ongoing process of staying vigilant.
And you know, this all leads to a much bigger question. The DPDPA really proves that even with the GDPR setting a kind of global benchmark, major countries are choosing to forge their own paths. So is that dream of a single, unified global standard for data protection slowly fading away? Or are we just entering a new, more complex and fragmented chapter of global compliance? That's really the question we're all left with. Thanks for tuning in.